It's 11:30 on a Wednesday evening, and you're in a small conference room with your two lawyers. Everyone is exhausted, a bit on edge, and you're finding it a bit difficult to focus your mind. Your thoughts are racing. Have we considered all the important points? Am I accepting too little? Asking for too much? What are the tax implications? Am I doing the right thing for my family? Litigation is a difficult situation at best. At worst, it's like a mini war. If you want to learn about Florida probate and trust litigation, stay tuned. Hi, my name is Brian Duffy, and I'm a Florida lawyer. Welcome to Duff Law Digital. Today I'm here with Jonathan Burns. He's of counsel with the Duffy Law Firm, and he assists us on our probate and trust litigation. Welcome, Jonathan.
Thank you, Brian. It's great to be here. Probate and trust litigation is a fascinating area of the law. It is one of my favorite areas of the law.
By the time you find yourself at settlement, as we opened this morning, hopefully you'll run through all the critical questions with your attorneys and other advisors, and you'll already know what your BATNA is. Today we'll briefly discuss what to expect in a Florida probate and trust litigation matter and how they evolve, generally speaking, and just exactly what is a BATNA. Stay tuned and you'll find out. Okay, so Jonathan, let's set the stage for probate and trust litigation. So, obviously there's some differences between probate and trust litigation, but for today's video, we're kind of treat them both together. This is our Q&A section for the Duff Law Digital, where we sort of give a top line overview of whatever the subject is. So today we're going to put probate and trust litigation together, talk about it generally speaking, but why don't you give us a little background on probate and trust litigation generally?
Well, it's a very emotional area of the law because you're often dealing with family members. And when a family member does something as it relates to probate and trust that you don't agree with, it affects you personally. This is not an insurance litigation dispute where you're mad at an insurance company. You can often be upset with a brother, a sister, stepmother, mother, that type of thing. So right off the bat, we get a feel for how our clients want to proceed in the sense of litigation. How far do they want to take it? And then once we know exactly how they would like to handle it, we can then diagram all of our procedural points, all of our motion practices, and take it from there.
Yeah, great point. In fact, we're opening with our slides in the background, and we'll cut some of those in, during the video. But one of the things that Jonathan and I like to do is sort of view it in stages. So on pre-litigation, before we actually make the determination to go ahead and file a lawsuit, one of the first things we're going to do is we're going to explore all the various alternatives to see if there's a way we can avoid litigation. I mean, generally speaking, it may sound counterintuitive that, you're meeting with your lawyers and you're angry about something. Maybe you feel like the executor or the personal representative of the trustee is not making a distribution they're supposed to make, or they're not treating a beneficiary fairly in some way. But the truth of the matter is, there are cases where we can resolve the issue before even going to litigation, before filing a lawsuit. Maybe a lawyer-to-lawyer conversation, which I know you and I have done a couple times, and it's worked for clients.
Yes, we had a recent case where we just made a few phone calls and we were able to get the case resolved because the lawyer and the trustee on the other side were aware that litigation and motion practice and even trial, if necessary, is something that we are happy and willing to do in the correct case. And they know that if they don't get it resolved early on, then this could be a long, drawn-out mini-war like you referred to earlier.
Yeah, that's a great point, too, because I think you and I have discovered, with our experience, that there are attorneys and law firms out there that don't really have the trial experience. And if they don't have the trial experience, oftentimes it's kind of a small community among the litigators. We sort of know each other. And if somebody's convinced that the other side doesn't have the commitment or they don't have the resources, then a lot of times they may sort of stonewall or they may just refuse to cooperate in any way. But if they feel like there's a real commitment there and the attorneys are prepared and they know how to bring the case through trial if necessary, that could have a tremendous impact on potential results, right?
Absolutely. It's entirely a leverage play. If you're a lawyer who everybody knows doesn't like the courtroom, or maybe the judges have no idea who you are because you're never in court, then that will take away from your client's leverage to get a positive settlement. And if you can do that earlier in the process, it can bring a positive result for the client, and it will also save a lot of heartache and emotional energy because they got it done early as opposed to a long drawn-out legal battle with maybe a brother or sister or aunt or uncle like we talked about earlier.
Exactly. Okay, so we've been talking a little bit about the pre-litigation stage, and this is the stage where you and I are meeting with the client. We're talking about the various issues, what it is that the client's unhappy about, whether or not there's any way we can resolve the issue in the client's favor without going to litigation. But after some point in time, we start to get the idea and we understand that this is going to be something that we're going to move forward on in a litigation posture. Now, you and I typically will really use this time in the pre-litigation to figure out exactly what's going on. One of the things that we talk about all the time as attorneys is people sometimes have absolute convictions that something occurred. I got a call the other day, and I don't know if this is going to end up being a litigation or not, or we're going to work with this client, but the client said to me, I don't trust my sister. I know she's doing things improperly. I know she did things with mom before mom passed, and now I'm going to sue her. Well, one of the things that Jonathan and I will do with the client is really sit down to see what our client may be absolutely convinced of versus what we may be able to prove in court, right?
Absolutely. And because it's such an emotional area of the law, some people think that, hey, this is what my intuition tells me. But if we don't have evidence of that, if we cannot present that to the court at trial and through motion practice, then it's really just intuition. It doesn't help us at all. So we are able to sit down with the clients, run through the pros and cons of our case, go through all the evidence that we need to prove our case to have a positive outcome at trial, and that way the clients have a better understanding of what is really going to be a part of the case and what is a gut instinct on their part.
And I feel like the entire period of this pre-litigation is all very useful because what we're doing is we're exploring what the facts are. We're trying to find out if we can substantiate what our client is convinced of but may or may not have proof of. We're also trying to identify what potential strengths or weaknesses the other side may have. And we haven't fired one shot in court. We haven't sent in any pleadings. We haven't done anything to actually institute a lawsuit yet at this point. And at this point, Jonathan and I, way we practice, will make one last effort. And typically that will be in the form of writing. We'll put a letter out to the attorney for the other side, and we'll identify the fact that we've made several efforts through discussions or phone calls or other sort of informal steps to resolve the issue and give them one last chance to resolve the issue before a lawsuit.
Correct, and that's an important part of it because when the other side knows that you're willing to file a lawsuit, they know that that last step is real and it is truly the last step before a lawsuit is filed, as opposed to just a shot in the dark, hey, maybe they'll throw us some money.
Exactly. And so I guess what we're reinforcing here is that in every phase of this matter, we're really focusing on preparation, examine everything you can, look for the strengths and weaknesses of whatever our clients are telling us, look and see what strengths and weaknesses the other side may have, and really can't overemphasize the need for preparation. I think in the cases where we've been successful, it's usually because we out-prepared the other side.
Absolutely. Preparation eliminates nerves. Preparation allows you to step into an arena, whether it's a sports, legal, what have you, and feel comfortable with what you're doing. And when we sit down with our clients and they know that we've exhausted all options prior to filing a lawsuit, and they have all the evidence in front of them, they feel prepared as well, and they feel more comfortable entering the next stage of the case.
Exactly. So now we're going to move on to discovery. So, I guess if we're outlining for the people at home, if you haven't been involved in litigation, and by the way, we are interested, so please leave us a comment below. If you have any experience at all in probate or trust litigation, just leave us a comment. Probate, yes or no, or trust litigation, yes or no. And that will help us to prepare future videos for clients and our fellow YouTubers on Duff Law Digital. So we're going to talk a little bit about discovery, and I'm going to let you speak about the various different aspects of discovery, the components of discovery. But at this point in time, this is where you as a litigator, what exactly are you looking for when you start the down the road on discovery?
So discovery comes in a couple different forms. We have written discovery, called interrogatories or request to produce, where we're either asking questions or requesting documents. That typically happens right after a lawsuit is filed. And then a few months after a lawsuit is filed, we have something what's known as depositions, where we sit down with potential witnesses in a case and we ask them questions and find out what their testimony, in the event that the case goes to trial, what their testimony would be, so that we know and we can prepare. Once you get to trial, there's not a lot of surprises because you've gone through this extensive discovery phase where you find out what the other side's arguments are going to be or what their witnesses are going to say, so that you can prepare your case for trial and you can prepare your client for what to expect and the possibility of success at trial. Now, I think depositions are a hugely important matter, a part of a litigation case, because you are taking the sworn testimony of potential witnesses. The idea is that they have sworn to tell the truth, and if they are lying, they are committing perjury. So once you get to trial, if they give testimony that is contrary to what they testified to in deposition, you can do what's known as impeach them by their prior testimony, or maybe testimony that they gave in a different case that that is related to similar facts. Once we get to trial, that testimony is supposed to be their testimony on trial, and if it's not, if they contradict their prior sworn testimony, we can do what's known as impeach them. And that is a hugely beneficial means of making a witness, particularly one who's being proffered by the other side, look bad, and is a huge benefit to our clients when a judge thinks that the other side maybe is not telling the truth.
Right. And it is important to have, judges are human beings just like everyone else. And even though they're guided by the law and hopefully they're following the legal, principles of the court and the procedures and everything else, they are human beings. And sometimes, especially in probate and trust litigation, we really get down to a sort of a fair or equitable consideration. And therefore, it matters if one party has unclean hands, is a term we use sometimes in equity in the law, versus, both parties being equally responsible for, the dispute one way or the other. The other thing is, Jonathan was just pointing out, rightfully so, that on the depositions, we focus on the deposition of the other party. I think everybody's seen this, Social Network, where Mark Zuckerberg was being deposed and, by the cameras, and he was, arguing with the attorneys and all those kinds of things. And, movies are wonderful, but the truth of the matter is these depositions they're a very important part of this process. And not only are we focused on what the other party is going to say and what they can or cannot prove in their case, we're also focusing and preparing our client for their deposition. So Jonathan and I will work with the client to make sure that they understand, exactly, what is the best way for them to put forward the facts that work mostly, in their favor without doing anything improper or withholding any evidence that would be required under the procedural rules. But again, preparation you can't overemphasize the need to prepare for the depositions of your clients as well as the other side.